morning. My name is David Majanja, Judge and Commissioner. Welcome.
Thank you, my lord.
Thank you, Honourable Commissioners, for that introduction. Honourable Kendago, before we go into the interview, where the commissioners will be asking you questions on your application that you have named for the position of a judge of the High Court, please confirm your county.
I come from Elgeyo Marakwet County.
And your ethnicity?
My ethnicity is Kalenjin from the Marakwet sub-tribe.
Thank you very much. Commissioner Macharia will take it from here.
Okay, yeah, just a few questions. Now, I'm looking at your CV, and you've worked, of course, quite well in the institution of the judiciary. Could you explain what is the key driver that motivates you into wanting to become a judge? There must be those things that, you know, in your life or in your career that, you know, have driven you into wanting to rise now to a higher level of a judge.
Thank you very much, Commissioner, and thank you, Commissioners. I appreciate the opportunity to attend this interview. My drive to become a judge is rooted in my commitment to serve in the judiciary. I have risen through the ranks in magistrate, joined the judiciary as a district magistrate to prof, and I share in the aspiration of every magistrate that in the ascension of the ranks in magistracy that would get to an opportunity to serve as a judge.
And you know, you are currently acting as a registrar of mediation, you know, which is a function that, you know, it's agreed that you've also carried out, you know, quite well. Now, what are the key, you know, lessons that you've learned in as a registrar of mediation that you think you'd apply if you were to become a judge?
Thank you, Commissioner. One of the biggest lessons that I have learned as the registrar mediation and overseeing the implementation of mediation in the judiciary is the importance of result-based management. So being able to look at reflections of how is it that we are doing things, but at the same time evaluating to see what is it that we can learn on a learning curve from what we are getting out of the data that we have, from the stories in mediation, from the implementation and the institutional frameworks, as well as the legal and policy frameworks.
My final two questions. There has been allegations or claims by some that mediation is being forced on parties, whereas it's supposed to be something that, you know, parties choose by themselves. But that notwithstanding that sometimes judges or judicial officers will opt the easy way out, so that, you know, as it were, they can remove the obligation of hearing the matters from themselves and push it over now to mediation. I don't know what would be your view about it. And also, as you answer that, to state what the best way of dealing with that issue, so that that perception is, you know, you know, it's not there, that parties are being forced into it.
Thank you, Honorable Commissioner. The implementation of court-annexed mediation as we have and the model that we have assumes a mandatory nature, which takes away the voluntary aspect of parties submitting to the process, but it doesn't necessarily require of them that when they go to mediation, they must go and agree. There was quite a consideration and issues that we've been talking about as a learning curve, as I mentioned, with the task force that is overseeing the implementation of mediation. And the lessons at that time borrowed from what is happening globally, as well as trying to work out the best model that we'd use to be able to give effect to Article 159. So borrowing from that and the considerations that were made, we adopted the model of mandatory mediation. We are aware of the challenges that this has come with, including the expectation by parties that they would want to have their say, or they would like to even have a greater, you know, like decision-making prior to referral to mediation. So in order to cushion this, we no longer refer matters directly. without mentioning them in court. So we give parties an opportunity that we can explain the mediation process to them. We can also tell them what their roles and responsibilities in mediation are and generally what to expect. Over time, from the pilot phase up to now, there have been some changes that have cushioned this to be able to address the balance of access to justice, including the issue of affording parties an opportunity to select a mediator of choice, and again, giving them an opportunity during the mentions that they can tell us if there are any issues that may hinder the parties benefiting in mediation.
My final question, you can already see that this branch of mediation is becoming big. In fact, I think even recently, for the first time, a budget was created even for the alternative justice system. You recall the retreat we had in Naivasha, where we all agreed that we need to focus resources on it. And you've done well. You are still acting, and it's a baby that you're still building. Then, of course, you'd want to become a judge, but wouldn't it be better then if we confirm you as the registrar of mediation, you build this baby, and once it's family established, now then you can cross over, because it's a big position also, registrar of mediation. Not to question why you'd want to become a judge, of course you have a right, but I'm just wondering whether you think that would be something that you would consider.
Thank you, Honorable Commissioner. I'd like to appreciate the Commission and the judiciary for the responsibility that has been given to me to midwife mediation and generally the implementation of it on a national basis. I have come back with a report card, and I am requesting to be allowed to take up more opportunities. I'd be able to still serve and support the implementation of alternative dispute resolution, in fact coming in from a heavier role of the experiences that I have had. Besides that, Honorable Commissioners and Chair, we have also worked on court annexed mediation from the pilot phase up to the phase where we are now. And besides the learning curve, we have also set up institutional frameworks that would be able to support mediation, and even if somebody else was to come on board and steer, we have an action plan that is already in place. We have set up tools. We are now on our 4th phase of implementation and national rollout, and the term that is coming to an end in July this year, we have also set in motion preparation of a 5-year plan that will be longer now, and of course leveraging on the gains and the guidance we have under the stage.
Honorable Kendagor, I'll ask you very simple questions that relate to your work as a magistrate.
Thank you.
These fall under the Sexual Offences Act. You're undertaking a trial of an accused person who's been charged with an offence under the Sexual Offences Act. You've come to the end of the trial, and you found the person guilty as charged of an offence under that law. And you're now at the point of convicting or sentencing the accused person. And of course, for you, and given the statute, you want to impose a custodial sentence. And assuming that the person has been in custody all through, when does the sentence begin to run?
Thank you very much, Honorable Commissioner. I had the experience of handling sexual offences cases in my time in magistracy and in Kakamega, and they were quite rampant at that particular time. And the issue of sentencing is something that remained a major issue all through. So at the time of sentencing, I'd be guided by the provisions in the Sexual Offences Act about the penalties, and depending on the age of the victim. In this instance, consideration as to whether it is an adult, and then there are provisions that are during the trial.
I'm satisfied with only one answer, but that's okay. We'll leave it for another day.
Thank you.
Thank you.
Yeah, thank you. Maybe I'll take you to the familiar ground.
Thank you.
And ask you when a party would invoke an arbitration. when and how?
Thank you very much, Honorable Chief Justice. A party can invoke arbitration where they have provisions in the contractual agreements that they have and have selected arbitration as the choice of alternative dispute resolution. They can also select or be referred to mediation when they, to arbitration when they have come to court and they haven't exhausted the remedy and the choice of alternative dispute resolution mechanism that they have as stipulated in their contractual agreements.
Yes, happy with that. Just tell us if you were successful in this bid to become a judge and an application was, or a petition was brought before you seeking to declare a statute or some provisions of the statute unconstitutional, what are the guiding principles that would guide you?
Thank you very much, my lady. In looking at a statute and whether it is constitutional, I would look at it from two angles. One is whether it contravenes the provisions of the Constitution, and on number two, on the issue of the process in which that statute has been developed. So the guiding principles that I would look at is number one, as to whether, first, again, going back to the issue of the principles of the purpose and principles of the Constitution. Then number two is about the issue of the Bill of Rights. Number three is on the issue of that it advances the law. And then number four is on advances the law, and number four is on governance, whether it promotes good governance.
Okay, very well. Finally, you have been sent to her station and there is a backlog of cases. I want you to tell this commission what you would do to make sure that the station becomes efficient.
Thank you very much, my lady. For our station to be efficient, it would go beyond just the sitting in court and waiting for the files to come and writing rulings and judgments. It is important to create a cycle where a quality cycle that would ensure that the back office as much as the front office is operating very well and in a coordinated manner. So I would look at it from an approach of creating the quality cycle right through from the filing of the case and right through to the processing of it to the time that it would now come before me as a judge.
That is active case management.
Yes, my lady.
What else would you do?
Besides active case management, I would also work on the issue of time, ensuring that we have a very organized schedule in terms of how we are handling the cases, and again, saving on time with the applications and the hearings in court. I would also apply the use of alternative dispute resolution mechanisms to handle the backlog that we have. And besides that, again, is to leverage on technology and ensure that we can tap on it for expeditious and efficient disposal.
Thank you. Justice Majanja.
Also did election scrutinies. I did taxations, and now in the transition into mediation, I have been largely involved in legal and policy development of the law and mainstreaming just to see that mediation comes in at a table where we can implement and be able to achieve the outcomes, not just in terms of the cases that are referred, but again the quality of success of the process. Beyond that, my Lord, I have in active engagement of the law also participated in very many deliberations that have happened, especially on the front of legal and policy, including representing the judiciary in conversations with the legislature about the bills that had been presented previously that touch on mediation and alternative dispute resolution.
Okay, so how does this tell us your judge ready? All this.
Thank you, my Lord. I have learned so much and gained so many skills out of my experience in alternative dispute resolution, and just generally the measure to look at cases from an interest of what are the practical solutions that can be put in place to be able to address these cases. And out of the skills and the leadership experience that I have had in court annexed mediation, I am judge ready to be able to serve and take on more responsibilities.
Thank you, Honorable C. Sorry, I had a line of questioning which I had prepared, but because of your paper, very, very interesting, in my view, very controversial topic. You wrote for your proposal for master's degree, you proposed a topic called Alternative Justice Systems and Criminal Justice in Kenya, revisiting the jurisdictional limits of masla courts in criminal cases. Masla courts. What are masla courts? For the benefit of members here.
Thank you very much, Honorable Commissioner. The masla courts is a traditional dispute resolution mechanism that is mostly applied by the Muslim community.
Okay, but in Kenya, we don't have, do you agree with me, there's nothing called masla courts? And I think that that's
yes.
your creation of your paper.
Apologies, my lord. The reference in context is the traditional dispute resolution mechanism.
But why
that
do you
we
call
have.
it masla courts in Kenya? We don't have that.
I think I may have maybe carried away with the angle of the research with which I was taking that takes a comparative consideration with South
Fine.
Africa.
Okay, as much as we love, and I think I do love, and we should promote AJS, but do you agree that in Kenya, under the Constitution of Kenya, that we are one republic, one state, and we cannot have different laws?
I agree, my lord.
And you agree that Muslims have personal law issues catered for by the Qadhi's courts? Tell me why we should have murder treated differently in different communities, or rape or defilement.
Thank you very much, my lord. It's not that the offences need to be treated differently or that the communities need to be treated differently, but rather an approach on how justice is being handled in different communities. And again, falling back to whose justice is it? So my examination and the experience that I have had in alternative dispute resolution is that sometimes, as we may hear the cases in court and pass rulings and judgments, they sometimes do not really address the question of justice as the parties or as the communities may perceive them.
What about the law? There were many wishes by communities, by groups. All I'm concerned with that you are, now I see that in fact I'm really wondering. There are two cases you gave us that murder cases
Yes.
have been withdrawn because of settlement by families or ethnic groups, and money is paid, blood money is paid. So why should we have a law like that in one community and not, and then the law is clear, the penal code is clear?
Thank you very much, my lord. The proposal that I have in this...
Like defilement.
Yes.
You have defilement, rape. A rape, the allegations that in northeastern province, girls, women are compelled by the elders to withdraw cases, complaints against their personal wishes, and they go and settle. Money is paid. Even the victim doesn't get anything. The elders share the money.
It's
Is that justice?
No, it is not, my lord. It is not justice, and it's very unfortunate that actually those incidences happen, And the umbrella that we have been having under alternative dispute resolution is that as much as we are promoting the use of alternative dispute resolution, as an institution, as a country, and the collective responsibility that we all have, especially with the justice actors, is to work together to ensure that we preserve the realm and uphold the rights of those that otherwise their rights would be violated by the use of alternative dispute resolution.
Okay. Thank you very much.
Thank you, my lord.
Thank you. CJ, good morning once again, Your Honor.
Good morning, Honorable
Just
Commissioner.
picking up from where Judge Ibrahim has left with regards to the AJS, what is your understanding of the theory, agency theory of jurisdiction? Because I know the task force has been speaking to the issue of agency theory of jurisdiction of AJS.
Thank you very much, Honorable Commissioner. So the agency theory looks at it in terms of conversations that are held right through with the mechanisms that we have, and a classification in terms of who is representing who in these conversations. So if I pick it up from what Honorable Commissioner was talking about, the issue of being had in AJS being used in murder cases, then the agency theory is who is representing who in this matter. Whose interests are we preserving? Are we looking at the interests of the people who are coming in? If it is in murder, you find that the conversations of the people who come on the table may not even necessarily be the first line of family for the accused person. So when you talk about the agency, it is about bringing on board to ensure that the real people who are affected by this or use of this alternative dispute resolution, or rather the address of the justice, actually reaches or is addressed to the main people.
And on the issue of, for example, defilement, you've mentioned about murder. How about the issue of defilement? I know there are many communities, not just even in northern Kenya. You know, in Ukambani, there are those who call something with regards to uji, usu something, where the elders drink porridge and an issue is resolved. So how would, if you are a judge and you hear, or you're in a community and you hear the elders saying they can handle defilement cases, if you are to use the agency theory of jurisdiction, how will you guide the elders with regards to that particular matter of defilement?
Thank you, Honorable Commissioner. First, the elders are not allowed to deliberate on matters defilement under the traditional dispute resolution mechanisms. So I would empower them and let them know that they're actually violating the rights of these children when they have these cases there, and they're not addressing the social vice. If you look at how this, with the study that I have had on how the processes happen, the children are never even part of the discussion. The issue of the weight of the offense is carried on more of like perpetrated by the family members, by the friends, by the village, the community, and while disregarding the rights of the victims. So no, they're not allowed to, and I would ensure that if I'm serving in a station where, and of course with the hope that all the court stations will be implementing alternative justice system, I will play a key role in the deliberations that we have, both at the level of the court itself, and again at the level of the members of the public who are the court users.
Okay, thank you. My last question is on an equal distribution of justice in the country. As an acting registrar mediation, what have you done to ensure that counties or regions and courts that are underserved by the justice actors get mediation? Because I believe maybe the word has not gone around the country much, but most of these mediation centers are in urban, well-developed cities, as opposed to the ground mashinani.
Thank you very much, Honorable Commissioner. So while with the regard of the scientific approach that we took to the rollout of mediation, which looked at courts that have a higher caseload, that have a huge case turnover,